the court will go back and watch the videos. However, I'd like to hear arguments from the state and from Mr. Scoggins today based on their motions that were submitted.
Correct, Your Honor. So we did submit Henderson video on the issue of English, ability to speak English. The Henderson video is outside of the case filing to this particular case. That's a separate citation from February. After this case occurred, the defendant was pulled over. He was communicating fluently with the Henderson officer. So that.
So let me ask that question then, because if that was after this case occurred, arguably we have to look at the time that he got pulled over. Did he speak English then? Did he understand it then at that time? And that's the issue that I need to look at. I can't look at what he knew 6 months later or 8 months later. I mean, arguably if somebody came into the States, and I don't know how long he's been here, but if somebody came into the United States and didn't speak English and then they took an adult education course and learned English and were now speaking it better and understood it better, but at the time that they got pulled over, they didn't understand, but then they've been studying it and now understand, that doesn't take away from the issue of what happened at the time.
That's very thoughtful. I understand Your Honor's argument. So certainly Your Honor can compare and contrast the video from the body cam from the day of, his ability to speak English, contrast that with and compare with what happened 2 or 3 months. I think the Henderson is February. This case occurred in December, if I remember correctly. So it's not too distant from the incident. So Your Honor has 3 tools, essentially, from the state's perspective. Your Honor can forget about the Henderson case. We can look at the interaction once the day of, his ability to speak. My argument on that, Your Honor did reference something about evidentiary hearing. My argument is that evidentiary hearing is not required if we do not need to extend the record that's before Your Honor, which is the body cam. The body cam shows that the defendant only spoke with officers, and more than that, he was talking with other people at the scene, from other parents. He was very cooperative. So in terms of the English language ability, I think the video will be very instructive for Your Honor to make that determination. Second of all, I would just note, and I did attach to the motion, the defendant never requested a interpreter for, I believe, 3 hearings until the particular day I cited in the motion. That's only one, after a couple court continuances, all of a sudden the defendant needs a interpreter. So that evidence suggests there's some kind of an afterthought about, okay, we can suppress him, how can we attack this blood? Again, my strongest argument, I would ask Your Honor to take a commonsensical approach by watching the video and listening to his ability to communicate. Was there any kind of delay? Oh, can you please, officer, I didn't understand, I don't understand what you're talking about, can you repeat that? Or, something like that, to indicate that his ability is not proficient enough to get valid consent. So that's the English ability language. In terms of, I think I said the word backwards, but in terms of whether the consent is voluntary, Your Honor, I think the video is also instructive in terms that where the officer, I cited the case where, it makes a difference when the officer's all up in your face, armed with a firearm, who say, hey, give consent. That's not what happened here. Everybody was extremely, based on what happened in this case, that's also part of the video. I'll provide another copy to the court showing what exactly happened there. Everybody's very distraught of what happened. A lot of kids were around, a lot of parents were around. Everybody's yelling, screaming because of what happened. The defendant was talking to many different people. When the officer showed up, they showed sympathy to him. Ultimately, the question here is this. Let's just say I'm sitting on a table, having lunch with my family, and I have a bag under my table, and the officer comes in and says, can I check your bag for narcotic? No reason at all. If I say yes, that officer can't check my bag. That's the extreme example. Nobody wants to see that happen, but the fact is, if somebody comes in, and the officer comes in and sees the bag, says, can I check your blood? You absolutely can't. And that's exactly what happened in this case.
But what about the argument that the defendant makes that they took his driver's license, they took him to the hospital, they kept him there, and then they arrested him? What about that he wasn't actually free to go and wasn't actually at liberty to be able to make the decision?
Correct. Well, he only went to the hospital because he consented. Where the consent occurred in this case, I said, Honor, see what in the video, he all occurred at the Lowe's parking lot, where this incident, near where this incident occurred. You can see multiple other parents were still staying. People stay after a traffic accident. They don't just leave their car there and say, see you later. Especially in the fatal accident. Nobody was detained. It's instructed that the defendant was let go even after the blood draw. Now, I can speculate, which Your Honor, actually, Honor, I'll be
Well, they
considering.
said that he wasn't let go. So there is a discrepancy between the state's statement that he was let go after the blood draw. They say that he was immediately arrested and booked
Is that what you-
after the blood draw.
For a different crime. But yes, he was never allowed to leave the hospital. That's from the police.
So this is what happened, and I don't think Your Honor needs to. He was arrested for DUI later because
Right.
the blood results took 2 days to come back.
Right.
He came back to the police station. That's why he was arrested.
Right.
He was cited on the day off for a traffic violation because there wasn't any information. Because one DUI case has happened, and there's 3 ways of proving DUI. The C theory is 2-hour window, where you have to obtain blood within 2 hours of actual physical control.
Right.
So in this case, obviously, the officer's intention is, okay, you know, from talking to him, are you willing to submit? You can see all this interactions yourself, Your Honor.
Okay.
Say, are you willing to just to say there's nobody in your system? The defendant said, maybe I'm talking too fast, I'm sorry. Yeah. I forgot, I'm sorry. When he was talking to the officer, he was like, no problem. I didn't drink nothing, take my blood. That's what started this whole thing, with him going to Vista Hospital. Yeah, I think that's what the hospital is called, where the blood draw took place.
Okay.
He wasn't arrested on the day off. He was cited. At that,
So then what's the so I need to know from defendant's perspective then, because the defense clearly says that he went to the hospital, they took his blood, and then he was arrested and he was detained. So,
Yeah, sure, and it was an exhibit D to my reply.
okay,
And it's the report that was submitted by Officer Sambana, who was the primary officer on the case. The last 2 paragraphs, he says, I transported him to the hospital where Officer Miller completed the necessary paperwork, nurse did the blood draw. As I was driving out of the parking lot, Officer Miller advised I needed to return with him because the doctor had not signed him out. Prior to being released from the hospital, I received notification from Motor Officer Denuza that he was placing Senobua under arrest for vehicular manslaughter and failure to pay full time and attention. I placed Senobua in restraints and advised him of the charge, which he said he did not understand or agree with. I then transported him where he was booked accordingly.
so that's not my understanding. I actually didn't see that. That's my apologies. My understanding is that a defendant was arrested after the DUI case. It was released the day off.
he wasn't released though. So here's what we're gonna do, because that is an important factor, and it is a distinguishing factor in this case between what you're arguing in your opposition and what they argued in their reply and brought to my attention. So I want a reply for you on that issue.
If I may also,
Yes.
let's assume that he was arrested.
Right.
It doesn't change anything for the state. Let's assume that the officer decided to detain him that day. First of all, you can see the decision to arrest him was at that point. Officer Lamana wasn't going to do anything with him. So until that point, when he was already ready to leave the hospital. But let's just say he had the intention to detain him at all times. I still argue on it. During the body cam, he voluntarily submitted to the blood draw. At that point, there was no decision to arrest. That's news to me. I'm sorry, Your Honor, I didn't catch that. My interpretation, because I know the defendant was arrested 2 days later. This was originally a North Las Vegas case. City attorney contacted me concerning this case because the blood result came back 2 days later.
So your argument is that the consent, it's not like they said, we're going to arrest you unless you take a blood test. And so his consent was prior to the decision to arrest him, and therefore the fact that they arrested him after they did the blood draw has no effect on the fact that he consented. Is that your argument?
Correct, Your Honor. So that's just in reaction to what you just argued. I understand now, I'm just, I didn't know, I frankly didn't know that he was arrested for vehicular. This is generally a citation for vehicular manslaughter. It's a misdemeanor up to 6 months where you committed a negligence while driving to result in the death of another. So first of all, vehicular manslaughter has no elements of a blood draw. So that has nothing to do with the vehicular manslaughter. Again, that's why the video is important. At that juncture, it's very chaotic. What happens when a fatal thing happens? Different officers will do different things. And this is kind of, if you want to have an evidentiary here, you will find out that they work in a team environment. All the information are coming in at the same time. That's why you have Officer Miller going to the hospital. I understand in the reply, the defendant states, it's Officer Samad who got the verbal consent, but I did present to the court the consent form, which is sent with Officer Miller, because Officer Miller was the one who went with the defendant to the hospital where he signed the consent form, which lists, hey, this is the normal process for blood draws. Are you consenting to this blood draw? And that's why Officer Miller signed it. There's verbal consent, as far as I know. There's also documentary consent. So that has nothing to do with the vehicular manslaughter. And this sounds like, at that point, the fatal detective, he's the primary, not Officer Samana. Officer Samana is a patrol officer who got there first, so he was interacting with the defendant. He doesn't have the expertise of the traffic view. He's just doing what the traffic is telling him to do. So that you can see all of these, regardless whether he was arrested or not. Just let's say the officer, the same example I gave, if the officer has some kind of pretextual reason for asking me why they want to search my bag, I'm like, oh, go ahead, please go ahead and search my bag. No PC at all. I just gave my consent through a normal interaction with another human being. I can absolutely do that. Now I can speculate. Let's say the defendant in this particular case didn't give consent. Then Officer Sterling needs to do a normal process, a warrant process, and then the Lowe's video was simultaneous. Officer Vincent Lewis went to Lowe's at the same time where the defendant is talking to Officer Samana and Officer Miller transporting them to get the blood draw. This is all happening at the same time. So PC is being developed at the same time. Officer Samana, as we testified during the preliminary hearing, did not have the benefit of watching the video. We're hearing multiple parents, including the defendant explaining what had happened. Everybody was understanding. That's why the tone, the atmosphere is important for your Honor to see. This is not the officer coming in like the case I listed. They busted into someone's motel room, standing over them, and the people's age is like 19 and 21, say, hey, we're going to get a warrant if you don't consent. That's vastly different from that.
And would your answer, I want to ask you that question, would your response be different as to whether or not this was voluntary consent if, while they were in the Lowe's parking lot, if the officer would have said something to the effect of, we are going to arrest you on suspicion of DUI unless you take a blood test?
Absolutely. That's a threat.
Right.
The difference between the cases I listed versus what happened in this case, I would admit to you, Honor, this happened very quickly. The officers came up and said, hey, this was through normal conversation. That's why I believe the first draw actually came within 2 hours. So the defendant was cooperative. We give him all the credit for that. So, that's the difference. It's absolutely absence of threat. I mean, in the video, you can see the closest officer was maintaining a perimeter, nowhere close to where the defendant is. So that's why I want you all to watch the video. No problem.
All right, I will. Mr. Scroggins.
Where to begin, Your Honor? So, I set forth in my reply, in the state's opposition, they laid out a number of factors that they believe supported the idea that there was consent in this case. I laid out in the reply that virtually none of those factors that they listed are actually supported by the facts of the case or the record. Your Honor started this out very appropriately by saying the state has the burden to prove by clear and convincing evidence that the consent was voluntary. They're not disputing that that's their burden. The facts that they have set forth to support the voluntariness of the consent are not supported by the record. The hospital issue is just one issue. They brought up, while I'm thinking about it because he just spoke, talking about leaving the hospital, the reason that that's an issue is because they claim in their opposition that that's critical to understanding this case versus other cases where the person was not allowed to leave. This person was not allowed to leave. Granted,
Well, but the timing is what's concerning here, because I would agree with you if they had taken him to the hospital and said, okay, well, you know, we're gonna arrest you if you don't give your blood, or we're gonna keep you here until we can get a warrant unless you consent. That I think I would understand and I would agree with you. But this is more of, he consented in the Lowe's parking lot, they take him to the hospital, and then they keep him on the vehicular manslaughter charge. So I don't know, it's almost a harmless error analysis. I don't know, it's a what comes first, the chicken or the egg, right? He consents first without any sort of threat.
Your Honor, and I understand that distinction. I only brought that up in my, I don't think it's as important as the state thinks that it is, because I don't think it proves consent one way or another if he was allowed to leave or not.
Okay.
They raised it as a factor that he was
Gotcha.
allowed to leave to show that it was voluntary. I only talked about that in response to that argument. So, given the fact that they have the burden to prove by clear and convincing evidence that this was voluntary, the factors that they listed out in their opposition are what I addressed in my reply. And none of them are supported by the record. I understand he says that he overlooked the police report, but that police report, Exhibit D, was the same police report that said that he did not have bloodshot, watery eyes, that his speech was not slurred, that he didn't sense any smell of intoxicants, and that his gait was steady. Essentially an anti-DUI statement in his report. So he's conceding in his report that he had no reasonable suspicion. Now, the state thinks that voluntariness trumps, and they even say in their opposition that you don't need reasonable suspicion or probable cause if someone gets consent. But if that's the case, Your Honor, what is the whole line of cases about Terry stops about? The police don't have the right to stop someone and ask them to search them for absolutely no reason. Where every search and seizure under the, going back to the earliest cases discussing this, says that every search must be evaluated for reasonableness, right? If the police are allowed to just randomly walk up to anybody and say, can I search you? That's a problem, Your Honor. I don't think that that's supported by the case law. If they need reasonable suspicion to request a blood draw in order to get a warrant,
Well, they need PC.
well, right. But to even get to the point of asking for that, they need reasonable suspicion, which goes to the detention issue, Your Honor. They took his driver's license from the moment that they were speaking with him. Now, there is case law that says that that is an indication that a person is in custody, that they are detained. Could he have just taken off and left his driver's license? Yeah. Would a reasonable person do that? I don't think so. Would a reasonable person believe that they were free to go when they didn't have their identification with them? I don't think so. So he was detained, Your Honor, and I cite the statute in the reply because they're saying, well, they didn't have any suspicion at the time, but they developed it later. He said they developed the PC later, which is kind of putting the cart before the horse. You need PC, right, to do the search. They're saying, well, they didn't have PC at the time, but they got it later. That's not how the Constitution works or the laws. But the statute for investigating an alleged civil infraction, which they're saying that this vehicular manslaughter offense would have been, and he was arrested for, we clarified that. if they're investigating him for that, then the NRS kicks in that says they're not allowed to detain a person for that purpose for more than 60 minutes without making an arrest, and they're not allowed to remove that person from the point of contact. That's clear in the statute. So if they were only investigating him for what they believed at the time was a traffic violation and not a felony crime, then they detained him over an hour and 20 minutes and took him away from the scene before they did it. So I think that violation by itself is very concerning. They bring up how chaotic and crazy this scene was, and I understand that, but Your Honor, that's the reason that the police have policies and procedures, and the reason that the courts have interpreted the Constitution to ensure that those are followed. And they were not. If you look at throughout this case, the reports that were done, the statements that were made, he talks about how different officers filled out what he called written, you have verbal consent, he said, and then written consent. I attached the transcript from the preliminary hearing, Your Honor. At that preliminary hearing, Officer Miller, who was the one who completed that consent form, testified. He never spoke with Mr. Chochi-Senobua. He never spoke with him. He filled out that form based on hearsay that he claimed he got. He didn't even say which officer. He said, I got it from another officer. That is in the record. That's testimony under oath. That can't be changed. And so there wasn't verbal consent and then written consent. If there had been written consent, that consent form that is in front of Your Honor indicates in the very top of the first paragraph, this is to be read to the suspect. And it has the quote from the implied consent law that explains to the suspect that they have the right to refuse, but if they do, the officers may get a warrant and then whatever other civil consequences are. That was never read to him because the officer who claims that he gave him verbal consent never explained that to him. The officer who filled out the consent form never spoke with him. So they've submitted paperwork in this case, Your Honor, to support this idea that he voluntarily consented, that on its face is misleading at best. If you read that form in a vacuum, it implies that the implied consent laws were explained to him, and that he was given the option of refusing, although there would be consequences to refusing. That never happened. But they chose to do that form because the officer knows that that is the proper policies and procedures that they're supposed to follow. The reason that they have those policies and procedures is so that we're not in court like this arguing about if things were done correctly. When the officers don't follow their own procedures, let alone the law, then we can't have any faith in the results of their investigation or what they did. Going back, reasonable suspicion I covered. I think you do have to have reasonable suspicion. Even if they were investigating him for the vehicular manslaughter and that was what they had reasonable suspicion of, that doesn't get them to the point of requesting blood because that has nothing to do with that charge, as he stated. To request the blood, they had to have reasonable suspicion to believe that he might be under the influence, which the officer affirmatively says he did not. Now, anything he discovered after that is completely irrelevant to whether he had reasonable suspicion to initiate that investigation. At the point that he asked him if he would give blood, and we'll discuss that in a second, but at the point that he asked him to do that, they'd already completed their traffic investigation. They'd already gotten his, well, they had his driver's license. They'd already gotten a verbal and written statement from him and told him to wait. They'd gotten their verbal and written statements from witnesses at that point. At no point did any of those officers, and again, I understand you don't have all the videos, but at no point, and you can review them after, but at no point does anybody say, we have probable cause to get a warrant here, right? They never asked him to do a breathalyzer, which is supposed to be the first step if you suspect intoxication, and it might be alcohol. Never asked him to do it. Never asked him to do any field sobriety tests. Now, I don't know, I don't have their written policies in front of me, but I believe Metro, this was North Las Vegas, I believe Metro requires them to initiate that kind of investigation in a fatal accident, right? Because, again, they want to make sure that they're doing everything by the book in case we wind up in court having to argue about this. In terms of whether he understood the consent, I cited case law, especially in the reply, that says that it's not enough for a defendant just to say, oh yeah, right, totality of the circumstance.
Well, it has to be a voluntary relinquishment of a known right.
Exactly, Your Honor, and there is no indication in anything in this case and in the video that his right was ever, he was never explained
What his rights were.
It was never explained to him. And the officer tells him, I don't suspect you of anything, but they would like you to give blood. The implication of that is, I'm on your side, buddy, and I know cops are allowed to do good cop, bad cop, right? But the implication is, I'm with you, but they, right, this amorphous they, want you to give blood. The language issue comes about because, yes, he can speak conversational English. I can have a conversation with my client. The reason that I started requesting an interpreter was because I came to understand through the course of my dealings with him that if it came to technical issues or legal issues, he didn't have a grasp of what I was trying to explain to him. A person can have the ability to speak conversational English, Your Honor, but not have the ability to understand things like what their rights are. It was brought up in the opposition that he had this case in Texas before, so the implication was actually, it was stated explicitly, he knows what the procedures are for a DUI, so he should have known he could refuse.
And in the reply, you make mention of the fact that it was dismissed, and so...
It was dismissed because the officer committed so much misconduct that they had to dismiss all of his cases after they terminated. So, again, their burden, clear and convincing, having been arrested by a cop in Texas who was so bad that Texas fired him, and the court and the DA's office in Texas dropped all the cases that he was the officer on, goes completely, I mean, we don't know what that cop did.
Right.
We don't know what he thought his rights were. When you have a cop that bad, you can only imagine, and Your Honor knows. And so I think the language issue is important. Not that he's illiterate or doesn't understand English in any way, but it is not his first language. He is not from this country. I mean, you go to any high school today and you ask a kid how many branches of government there are, some of them won't be able to tell you. But if you ask them if they have the right to remain silent, they'll know. That's right? That's American culture. We understand that we have some kind of rights. Right? He wasn't raised in that environment. So, to say that they proved by clear and convincing evidence that he gave actual consent, voluntarily, knowing he had that right, and the case law also says the right to withdraw the consent is also a critical issue. He was never informed he had the right to withdraw the consent. And I submit, Your Honor, and if we had an evidentiary hearing, he could tell you, I don't want him to speak on right now, but if we were having an evidentiary hearing, I would ask him to give limited testimony on this issue. He believed that if he told the officer no, then he would have been arrested for not saying yes. That's what he believed.
I have a question, because I've heard enough, I think, and I need to watch the video, but I do have a question. Was the preliminary hearing transcript filed?
I attached it as an exhibit
Okay,
as well.
all right, I want to take a look at that as well. I'll hear, I've heard enough from you, Robbins, respectfully. Okay, go ahead.
Yeah, Your Honor, there's some mentioning about the Terry stop. You know, this case is vastly different from the fact pattern of Terry stop. Now, in this case, you have a dead body of a 5-year-old child under a vehicle. In terms of 60 minutes, I think that's the fact if about here, Your Honor, the prolonging. Written consent, we just submit a form, it does have it, I guess their argument is even if it's a written form with a different officer's name on it, his ability to read or comprehend it is different, so that, Your Honor, requires.
Well, but if there's a preliminary transcript where from the preliminary hearing, if that officer says that he relied on the other officer telling him that consent had been given, and he didn't actually read that form to him, then that written consent is as good as toilet paper.
Well, I disagree, Your Honor, there's words on there, unless you want,
If he was not explained those words though, if he wasn't read those words by that officer, you had a problem.
first of all, verbal consent is good. Officer trying to ensure this, to ensure his right by giving him a form, say, this is the DUI form. He wasn't arrested for DUI, that's the only consent form in traffic. He's given that to someone, it's an extra layer of protection for the officer. If they didn't do it, my argument is the same, that you, Your Honor, can watch the video and determine whether that consent was voluntary and good, okay? And we're getting into this, all these reasonable suspicions, again, Your Honor, have to rely on the hypothetical I gave you. The officer just comes in and asks to see your bag.
I don't know if that's true. I don't know that an officer can just come up to you and stop you and say, I'd like to see what's in your bag. And that if you give consent, you have to have some sort of reasonable suspicion in order to be able to stop somebody as a cop.
I disagree, Your Honor, I can submit some extra.
If you would like to do a sir reply on that issue, I will allow it.
And, Your Honor, and my final argument is you don't need to be read your rights to understand what's going on until, the thing that comes to mind is the third party consent. Let's say if you're someone who lives with you was target of the investigation. And officer comes and knock on the door. The person who's target of the investigation is not at home. A third party can say, oh no, you can come in. Does the officer need to read that third person, hey, just letting you know anything you can be found in the house can be used against you? Now the target is the person, but the person who happens to be there. No, the officer doesn't, she's not, or whoever opens the door is not suspected of these crimes.
But if that person cannot give consent to an area that they're not allowed, so i.e., if you are roommates and you have your own room, and the roommate says, oh, you can go into this room, if they don't have the ability to say you can go into my roommate's room, then anything that's found in that room by the officer would be not valid consent.
Well, I'm just using that as an example.
It's not a good example.
The truth is, my argument is I get it, Your Honor, what the point is now. I'll submit additional authorities on what is voluntary consent, but my argument is he was not in custody at the time when he was giving voluntary consent. You require custodial interrogation, even with what they represented today in the report. The officer didn't decide, that's after we gathered information. What if the defendant didn't give consent in this case? What would have happened is the defendant would remain at the scene for the fatal investigation, like every other witness who weren't involved, and they would have gathered the video from those. The reason why he got transferred to the hospital quickly was because he consented, while other stuff was going on.
Well, but here's the problem. I've got an affidavit that says I have no reasonable suspicion that this person was drinking and driving. I've got somebody whose license has been taken at the scene, and whether or not you think that that isn't enough for him to believe that he was under a hold by the officers, you have to prove by clear and convincing evidence that it was a knowing and voluntary relinquishment of a known right. And based on all of the things that the defendant has brought up, I don't know as we sit here right now that it was. I'm going to go back and I'm going to look at the videos, and I'm going to wait for your supplemental authority that you're going to provide me on the reasonable suspicion and the ability to stop. But until I get that, I'm not going to make a decision. But I'm going to say from what I've heard today so far, there's an issue. All right?
May I
So-
just, point out one thing, Your Honor?
Sure.
You brought up the preliminary hearing transcript. I attached it as Exhibit B.
Okay,
And on page 38 is where Officer Miller testified. I asked him if he had any conversation with the defendant about the consent. He said, no, Officer Samad did.
Verbal. I get it.
Okay,
I'm
I
not
just
saying
wanted to
that
point out where it
Officer
was in the
Miller,
record.
I'm not saying Officer Miller got it. Anyway, that's even not my crux of my main argument. I'll brief that in the supplemental. So how about, Your Honor, what do Your Honor want to see? 10 days and then whatever.
whatever you need,
Okay.
however long you need.
Okay, thank you, Your Honor.
Do I get to respond at all?
Of course,
Yeah.
I have no problem.
Yeah, that's fine. So, what I will do is I will wait to get your supplemental. If you wanna do a supplemental reply, that's fine. And then if I need additional argument after that, you will get a notice of hearing. If I don't, I will simply issue a minute order or a regular order on the issue. Okay?
And I also get the video.
Yes, please.
Yeah.
I'll get that to your
Okay.
chambers today.
Thank you.
Thank you, Your Honor.
Thank you.
I have one more that I think we could call.
Are we back online? Yeah. Okay. No. No. Well, yeah, why don't you? But it's, it's not gonna be due until we actually get the supplement, or these 2 months from when we get the supplemental briefing. So, we need to make a note. Set a tickler, yeah, do a 30-day chambers to make sure that we get the supplemental briefing, and then we can do an under advisement from the day that we get the supplemental briefing. All right, perfect.
Page
20.
20, Your Honor.